Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. Today is Saturday, July 12th, and in looking at both the court docket and the case summary page in Idaho versus Kohberger, we note that there was nothing new filed, either on the court docket and no notations of any new filings on the case summary page, which was last updated. It looks like 2:06 p.m., the afternoon of the 11th of July. It is sometimes just as telling when a document is not filed as it is when it is filed. By way of example, there had been some speculation, some talk, some discussion. Could Mr. Kohberger, if he had second thoughts regarding his plea of guilty, 5 counts that were entered at the change of plea hearing in open court back on July 2nd, 2025, could he possibly go back and seek to have those guilty pleas set aside before sentencing, which is scheduled to occur later in the month, the 24th of July to be exact? And yes, there is legal authority. It's a rule of criminal procedure in Idaho that says that a defendant can, but there needs to be a motion filed if they're looking to set aside or to vacate potentially the prior guilty plea entries. Nothing on the docket indicating he's doing anything to challenge his plea deals as of July 11th. What also is interesting that's not on the docket is there is no responses that appear on the case summary page, notations of responses from the state of Idaho or the defense to the motion to be heard as interested parties in motion to vacate non-dissemination order, memorandum in support of said motion, and 2 declarations which are evidence that were filed by the media seeking an immediate setting aside of the gag order on July 3rd, 2025, and citing First Amendment violations. As of the 11th, yesterday, no response notated here from the state, no response notated from the defense, which is kind of interesting because unless they filed something very late in the day on the 11th, which is possible, sometimes the parties will file something on a Friday, especially towards the end of the day. Possibility the response was filed late in the day. If it wasn't, the next opportunity for either side to file such a response is not going to be until the 14th, which is Monday, because the courts don't work over the weekend. And then that's going to be just 3 days before the hearing. Judge Hippler set the media's motion for virtual hearing on the 17th of July. And if you'd like to look at the notice of hearing, it was dated and filed on the 10th of July. The other thing that's not notated on the case summary page is any court order regarding the state of Idaho's July 9th, 2025 response to the defense's request for discovery. And it's unclear to the public what it is that they're filing here because it's under seal. There is a motion here and an exhibit that is under seal. The motion is seeking to permanently have that document be under seal. It's temporarily under seal right now, awaiting a court ruling. There's no order that appears on the docket as of the last time. It was updated again the 11th of July. One additional point, there is no publication of the 2 public documents that the state filed on the 9th of July. The response to request for discovery, and then the motion to redact or seal this Exhibit S1 to the state's response to defendant's 24th supplemental request for discovery. It's rather interesting that 2 days after it was filed, it still remains off the public docket, both of those items. Until next time, this is Kathy. Thank you for joining us today.